Welcome to the top 12 highlights of Chapter 2, looking at the constitutional foundations. I'm Mr. Rodman taking you through the highlights, and let's kick it off with the U.S. Constitution. Let's look at the articles of the Constitution. Now, keep in mind these are enumerated powers, so these are the powers specifically enumerated or spelled out in the Constitution as to what the national government has. In Article 1, we look at the powers of the legislative branch. Article 2 showcases the powers of the executive branch, the president, vice president, and the cabinet and the bureaucracy, so forth. Article 3 looks at the judicial branch in terms of what powers they have there. By the way, Article 2 also looks at the Electoral College in terms of how a president is elected or selected rather than elected by direct democracy, but an electoral college, many of which electors back then were chosen by state legislatures. Article 4 looks at federalism, that sharing of power between national and state governments, as well as interstate relations, how states should be working together under the Constitution. Article 5 looks at the how to amend the Constitution. We've done that 27 times, the first 10 in the Bill of Rights, and we'll talk more about those in a minute. But that process in terms of 2/3 of Congress, 3/4 of the state legislatures, or 2/3 of Congress and 3/4 of state conventions. And again, we'll look at that in more detail coming up in the top 12 highlights. Article 6 looks at the Supremacy Clause. When national and state government laws conflict, who wins? It's the national government that is supreme over the states. And then Article 7, ratification of the Constitution. Unlike the Articles of Confederation, in which all colonies needed to agree in unanimity, a unanimous vote, ratification of the Constitution only required 9 of 13 colonies or states to ratify the Constitution, which would make it much easier to also amend it in terms of ratifying it, but also in terms of amending it with that 2/3 of Congress, 3/4 of the states. And then we have the Bill of Rights, the first 10 amendments, and we would go on to amend the Constitution an additional 17 times since then, all the way up to the 27th Amendment, looking at being approved, one of the original 12, but wasn't actually ratified by the state legislatures until 1992. So over 200 years later, the 27th and the last amendment thus far that we've had as the addition to the Constitution. Federalism is this sharing of power between the national and state government. Think of it like a handshake. The national government on the left-hand side, the state governments on the right-hand side, and it is a sharing of power. They are shaking hands, sharing in that power. We've seen that in Hurricane Harvey. We saw that in Hurricane Irma. We've got the national resources of FEMA, the Federal Emergency Management Agency, and other national departments and resources of the federal government. We've got state government, we've got local governments on the ground, and various other organizations within the national and state government working with local governments in order to share that power. That's all about federalism. That's essentially what it is. The separation of powers. Remember, Montesquieu talked about this, the importance of making sure that government didn't come between the natural deism and the people, between those natural rights, but making sure that social contract that Locke would talk about made sure that if government was going to fulfill a purpose, that they had separate powers to keep any one branch from becoming more powerful than the other. And this is what led to the first 3 articles of the Constitution focused on the separate but distinct powers that the legislative branch has in terms of making the laws, the executive branch in terms of enforcing the laws, and the judicial branch in terms of interpreting those laws. Now, that's not the same as checks and balances, because separation of powers is just talking about the separate powers they have. But the checks and balances here talk about the check that the legislative branch would have on the executive branch in terms of approving presidential nominations, controlling the budget, impeaching the president, or passing the laws over the president's veto. All of those checks from the legislative branch on the executive branch. What checks the executive branch has on the legislative branch then would include the president vetoing any congressional legislation. We also see that the legislative branch is checking the judicial branch by confirming the president's nominations and impeaching judges, holding impeachment proceedings in the House and removing them in a trial in the Senate. The judicial branch then can declare laws unconstitutional in checking the legislative branch, and the judicial branch can also declare presidential acts or orders unconstitutional, checking the executive branch. The executive branch then can check the judicial branch by nominating judges to the bench on the Supreme Court and the circuit courts, courts of appeals, and so on. Now, Dr. Magleby in the book talks about divided government versus unified government, and we see that political parties definitely play a role here in that separation of powers. Madison and Jefferson didn't necessarily see a problem in political parties slowing the government down. If anything, gridlock wasn't necessarily seen as a bad thing. One-party government was too easy to get things done, and the last thing they wanted the national government to do was to be able to get things done quickly. That's why you saw the checks and balances in terms of having to override veto and having to get consensus from the president in order to sign a bill, or consensus between the House and Senate in order to pass a bill. So the idea here was that gridlock would slow the Congress down. It would slow the national government down and keep them in check in terms of making sure that they were doing what the people really wanted and doing it thoughtfully, like the Senate, doing it very cautious and deliberately, but making sure that it was in the best interests of all of the people in the American government. Judicial review, this idea of declaring whether a law is constitutional or unconstitutional. We see that this isn't an explicit power in the Constitution. It is a power that the courts took on in the Marbury versus Madison case, where we see a stronger role in terms of judicial review. And this is the bittersweet moment of Marbury versus Madison. Jefferson won the battle but lost the war. He won the case in that he didn't have to honor the appointments that Adams had made, and we'll talk more about this when we get here. But the idea is also that the courts would then step in to determine the constitutionality of what the Congress and the president are doing, and that he wasn't necessarily too keen on. So he essentially won the battle, lost the war. And we have seen a number of significant acts, such as the one I mentioned in class with Clinton v. City of New York, in which they step in to declare the line item veto unconstitutional, a law that was passed by Congress, signed by the president, and then they declared it an unconstitutional usurpation of power by the executive branch when the legislative branch was tasked with making laws. The Marbury versus Madison case, in a nutshell, was essentially Marbury getting an opportunity to get an appointment from John Adams, President Adams at the time, who was leaving office, but the appointment was never delivered, as in the old days. It had to be delivered in order to take effect, and Marbury sued Madison, saying that Madison, the new Secretary of State, had to deliver the appointments made at the 11th hour by President Adams. Jefferson obviously didn't want that to happen. He didn't want Federalists taking these positions. He wanted to be able to appoint his own people, and so Madison didn't deliver, and of course Marbury sued. And this is the case that we saw that basically brought up judicial review. The Supreme Court declared that that Thomas Jefferson, the new president, didn't have to honor Adams in that role, but it also created it established a new precedent for the court, a precedent or a new routine or way of doing things for the government, a pattern or a history that basically said, now we're going to be ruling on the constitutionality of laws, and the Supreme Court's going to have a say in those laws, and that's really what judicial review is determining that constitutionality. We see this used a lot in terms of litigation, where legislation may not be possible, and so we see that they'll use litigation in order to get things done. We see this a lot with interest groups. They've taken it to the Congress, they've taken it to the president, they can't get any action, and so they take it to the courts. Brown versus Board of Education is a great example of this, trying to desegregate schools. And so looking at that, looking at Congress, appealing to Congress to do something. Congress wouldn't do anything. The president at the time, the president wouldn't do anything, so they took it to the courts, and they said, okay, we'll take it to the Supreme Court, and that's where the Supreme Court ruled unanimously to overturn Plessy versus Ferguson, that 58-year-old law from 1896 that basically said separate but equal was the law, it was constitutional, and a unanimous ruling to say that it was unconstitutional to segregate schools. Now, that would take a lot longer to put into effect, but at least the ruling was a great example of using litigation to force judicial review and the courts to declare something, to determine its constitutionality, and in this case, to declare that law unconstitutional. Methods of changing the meaning of the Constitution, we see a number of ways that Congress can kind of work in order to change the meaning. A lot of times they'll try and draft a law that goes around what the Constitution says. We see that as somewhat of a statutory construction, in that they're building a law around the Constitution without touching it. We also see the process of elaboration, where they're trying to fill in the blanks of something that is addressed there, something that is addressed in the Constitution, but they're trying to define it a little better. That process of elaboration, and then we see in the Judiciary Act of 1789 is a great example of changing the meaning of the Constitution as it relates to the judicial branch in establishing, and Congress had the power to do this under the Constitution. Article 3 only talks about the Supreme Court, and really Article 1 gives the power of organizing or reorganizing the judicial branch below that Supreme Court level. It gives that power to Congress, not to the judicial branch. They have the power of the budget. They can also organize them, and the Judiciary Act of 1789 established that, much of which we still have today in terms of the structure of that court system, again, beneath the Supreme Court. Now, the Congress can also determine how many are on the bench. Someone brought this up in class, the idea of President FDR, Franklin Delano Roosevelt, trying to pack the court in order to get his New Deal programs determined to be constitutional when the court was really ruling them unconstitutional. But again, Congress has the power to do that, not the president, and Congress did not take action on that particular issue. So that isn't an issue in which we see there. Another example that we see here in terms of changing the meaning is impeachment. Remember, impeachment is the idea that you are bringing charges and voting on charges, articles of impeachment, to take from the House of Representatives. Those members of the House would then go over to the Senate for the trial, and the senators would sit as jurists in that trial to be overseen by the Chief Justice of the Supreme Court. But only serving in that capacity as overseeing the trial. And the members of the House that are leading the charge on those impeachment articles would then go to the Senate in order to make their case for these high crimes and misdemeanors. But as we know, this is so vague in terms, and we have not seen any sitting president impeached and removed. We've had two presidents impeached, Andrew Johnson after Abraham Lincoln, and we have seen Bill Clinton. William Jefferson Clinton. Andrew Johnson almost lost that trial in the Senate by one vote, where the impeachment trial of President Clinton was not close. There was not that was not in jeopardy in terms of votes at that time. But the high crimes and misdemeanors is pretty vague. So how Congress determines whether to bring someone up on articles of impeachment, we see this all the time. There was a member of the House in the last 6 months or so that it's already tried to file a bill of impeachment against President Trump for reasons, because the high crimes and misdemeanors is so vague. Now it hasn't obviously gone anywhere, but the idea is that this is pretty vague, and so House members kind of look to that in terms of their interpretation. But again, without any momentum behind it, it's probably not going anywhere. Executive orders and presidential acts, let's talk about those for a second. The president has sweeping powers, especially in times of crisis. And we see this when President Lincoln suspended habeas corpus, the right to know what I'm being charged with. There wasn't enough time in arresting people during the Civil War to be able to bring them before court and charge them. So he suspended that writ of habeas corpus. In times of crisis, we see this. President George W. Bush, after 9/11, did this. Also, he suspended habeas corpus for enemy combatants of the country, holding them in Guantanamo Bay, Gitmo, in order to try and thwart the terror attacks and get to the bottom of it. The president can also use executive orders. I mentioned this in class, the idea that President Truman use this to desegregate the military in terms of an executive order that would do that. Now remember, those can be challenged in court, and Congress can overturn them in passing a law. The president may veto them, but if they can override it, they could potentially have the power to change that, and the court can rule it unconstitutional. But it is a power that the president has, and we see that used quite often. The latest being the travel ban, immigrants from certain countries being banned from certain countries from coming into the United States. That is making its way through the court now. Now the Supreme Court has said they will hear the case, but they are allowing certain parts of it to be enforced, and the stay or the freeze not to go in effect in some of parts of that particular executive order. But the president has the power to issue that. And again, Congress and the judicial branch, the legislative and judicial branch do have powers to change it if they want to. But again, it's unlikely to do so. Are you going to get both the House and the Senate to agree on a bill? It's hard enough right now getting them to agree on bills that they agree on, let alone something that may be contentious and also would go against the president's wishes. And right now, being a unified government in which we see we have the House, the Senate, and the presidency all in the power of Republicans, that is unlikely to happen. In those terms. Executive privilege, the idea of, hey, I'm too close to the president, my conversations are very valuable, and the last thing I want to do is be hauled before Congress in order to be asked to basically spill my guts about what the president and I talked about. So the president can claim executive privilege for particular aides that are close to him, ones that many times are White House staff, those working closest to him. But Congress can try. They can try and issue subpoenas to appear, and that would have the full force of a judge basically issuing a subpoena just to appear before a court. Congress can also impound funds in terms of the funds for a particular area. The president has tried this. Nixon tried it in terms of not spending money in particular areas, and Congress came back with an act that basically said, if you're going to do that, you got to let us know because we have the power of the purse, not you. You need to spend the money where we say, or else you need to give it back. The power to send troops is a role that the president has as well, and we've talked about that in class. The bully pulpit, a little more amorphous in terms of not quite the same enumeration as sending troops into harm's way, being commander-in-chief, but it is a power that when the president speaks, people listen. When the president tweets, people listen, and sometimes good, sometimes not so good, but there are trial balloons pushed out there as well that we'll talk about in Unit 2, but the idea of trial balloons is to throw an idea out there and see if people like it or hate it. If they hate it, you disavow it, you disregard it and pretend it doesn't exist. And if you like it, then you say, oh yeah, we came up with that idea. So the idea there is that the president can really use that bully pulpit to change the agenda. And we see this with the media as well. The president in many cases is perceived as having a lot more power than they do in this area, and they use the media to their advantage. And we have seen President Obama and President Clinton, President Bush, and President Trump all use the media today to try and set the agenda, to try and change the tone in terms of what they're looking for there. So they all try and use the media to their advantage. Judicial review also includes judicial interpretation, and we'll go into more detail on these cases. But I mentioned the Brown versus Board of Education one earlier in terms of the judicial branch reversing itself from an earlier ruling, the Plessy versus Ferguson case, in which in 1896, when the court ruled 8-1 that they were going to say that separate but equal was constitutional, it was the law. It took them 58 years to reverse that in a unanimous decision in Brown. So they are interpreting the laws. They are interpreting what the Constitution says about this, and it is an interpretation. It is not mentioned in the Constitution in terms of specifics, and so they're interpreting based on their perspectives, and this is important. Griswold v. Connecticut is a case in which the Connecticut law basically said that people couldn't talk about family planning services, and the concern was with at the time was that that this was a right to privacy issue. And so the court interpreted that right to privacy, which ultimately led to the right to privacy issue, the penumbra of amendments, that being the First Amendment, the Third, the Fourth, the Fifth, and the Ninth Amendments, being a part of this penumbra of amendments that created this right to privacy. Again, it's an interpretation. There is nowhere spelled out in the Constitution or the amendments where it says there is a right to privacy. But it was cobbled together in this Griswold v. Connecticut case and then used as an argument in the Roe v. Wade case that basically said banning a law banning all abortions is unconstitutional. So even though they're not mentioned, judicial interpretation definitely takes that to its next level. And we do this in two ways. The originalist approach, the idea of strict construction, exactly what it says, word for word. What does the Constitution say? What does it mean? We see more conservative justices taking this originalist approach. Antonin Scalia, for example, the late Antonin Scalia, who died about a year and a half ago, took this originalist approach. And his replacement, Neil Gorsuch, also takes a very strict construction approach. Then we see the adaptive or loose construction is, well, what would the Constitution mean today? What would it mean in today's terms? This is more the loose construction or the adaptive approach, trying to see it as a living, breathing document, something that adapts to the times and what those times say, and we need to be responsive to what the times are saying about the Constitution today. And that is more of a liberal viewpoint in that we see more liberal justices like a Ruth Bader Ginsburg that is looking at this in terms of what the Constitution, this living, breathing document, is saying today. So those are two very different interpretations, and obviously you have two very different outcomes in terms of their approach. We talked about this in class, but just to recap, how do we amend the Constitution? Remember, phase one is the national government. That's a two-thirds, two-thirds. So this column is two-thirds by either Congress or a national convention. And then phase two is 3/4. The states, either state legislatures or state conventions, need to approve it by 3/4 of those states. The most common method we've used in 26 of 27 amendments was by Congress and then the state legislatures to basically approve it, 3/4 of those state legislatures to approve. This has been the most common method, 26 of 27 times. The only exception to that was the 21st Amendment, in which we saw state conventions were used in order to repeal prohibition, that 21st Amendment. The National Convention, obviously a very concerning approach to James Madison and Thomas Jefferson. The concern of opening up a convention could lead to throwing out the Constitution, just like the National Convention that led to throwing out the Articles of Confederation. So you will see those Federalists that take that Federalist approach will be less likely to be concerned about a National Convention because of that concern about throwing out the Constitution altogether, which is why we don't really hear a big clamoring for national conventions or national conventions and state conventions in that approach. The most common is usually Congress and the state legislatures in a 2/3, 3/4 type of scenario. And then lastly, it's important to note a couple of things on amending the Constitution, that states can't unratify an amendment. Once they've ratified it, they're done. There's also no time limit on ratification except when Congress specifies, and many times it's a 7-year period. The 27th Amendment, as I mentioned, was one of the original 12 amendments that was part of the Bill of Rights that was never ratified. So it took them over 200 years to do so, and they did in 1992. But that was one that didn't have a time limit on it. So they had all the time in the world in order to ratify that one. But usually Congress will give a 7-year period, and the ERA amendment that was looked at and wasn't approved, actually the time limit expired before the states ratified it. Congress did pass it, sent it to the states, but not enough states ratified it in time for that 7-year period for it to take effect. And then in terms of our last highlight is really about moving towards a more direct democracy. We have seen a lot of this in terms of, for instance, the only real role back in founders' days, that the people voted was really for House members. Senators were elected by state legislatures, and state legislatures, I guess you could say could be elected, but from a national point of view, the president was elected by electoral college, senators by state legislatures, House members were really the only ones. And look at all the people who didn't have the right to vote anyway. The 15th Amendment brought us African American men that had the right to vote. Then we got the right to elect our senators directly in the 17th Amendment. The 19th Amendment allowed women the right to vote, and then the 23rd Amendment allowed D.C. To vote in presidential elections, those 3 electoral votes they get. So we continue to see an expansion of that electorate, an expansion of more people being invited into that more direct democracy. But it is still a representative approach to that direct democracy that we see today. And as we mentioned with the Electoral College, the presidency is still, although there's always a clamoring, as we heard in 2016 and we heard in 2000, for people getting rid of the Electoral College, it is still alive and well. I hope you've enjoyed the highlights. I hope you found these helpful. Good luck on the quiz, good luck on the test, and have a great day.